to do a PowerPoint on the significant areas of the act that we all need to highlight and be aware of, what makes, what changes, and then um, Jan is going to cover the draft agreements. We've worked together in making revisions to the participation agreement and to the attorney collaborative engagement agreement, and we haven't rewritten the whole thing. We've really just tried to add those pieces that are consistent with the act that we think people need to be aware of and including. And all these materials are going to be, it's my understanding, going to be added to the website so people can access them. I'm not sure if the act is already on there. We did attach that as well. We noted that there was an inconsistency in some of the formatting for the act. So there may be a more polished version of the act that we'll include on the website after the meeting. Okay. And before we start, I saw Cheryl Smith, there she is. I don't know if Teresa Cole is on here, but Teresa, formed the VACP UCLA task force several years ago, trying to corral people interested and help. She served some time on the IACP committee on the UCLA. And so she deserves a lot of credit. And she and Cheryl and the number of emails has been amazing, and they have always been extremely responsive. And, I know there's other people on this group that have worked really hard. Michael's worked really hard. Jen and Jan have really worked hard on the task force. I can't possibly include, everybody who, I know Emily Baker has done a lot of work to help us with reaching out to our legislators and trying to keep track of that for all of us. So if I miss anybody, it's not intentional, but it was a real team effort. So just, a little bit of history about, the act. And one of the things I want to say up front is that there was a question about how does the act address training? And does anything change about training? And so what we agreed as presenters was that we didn't want the focus of this meeting to be about whether you take a case with someone who has not gotten training. I'm going to address some of the discussions with the study group that formed for the Supreme Court study group about the discussion about training. But we agreed that as presenters today, we were going to defer the discussion about how do you handle taking cases with people who aren't trained as a separate topic, because that could take over. And we really felt we wanted to focus on the real important elements of the new statute. Okay. So the history, the Uniform Law Commission, that is a group of lawyers, judges, law professors, legislators, legislative staff members. These are, people that are part of this nonpartisan commission who are responsible for drafting legislative acts that may be helpful across the state so that there can be some uniformity on certain topics. So in 2010, the Uniform Collaborative Law Act was prepared and became one of the uniform acts of the commission. And at that time, Lane Needler was our Virginia representative, and he actually has continued to be the representative on the Uniform Law Commission and was very involved in guiding us as we tried to get our statute passed. So with the passage of the statute, we're the 21st state as I see it. I know there's a few states that are pending. I think there's 3 that have something pending. So we're approaching a majority in the states, we're getting there. And I think it's Missouri, New Hampshire, and Colorado who are still working, have something, in the works. The key, in looking back on how did we get here, I think one of the key elements was getting a patron who also knew, who was a lawyer and who also knew alternative dispute resolution. And, Delegate Rip Sullivan, he served with me way back in the mid 90s on the joint ADR committee for the state, the VBA and the VSB. And he was one of the chairs. And then I think we were right in line next to each other. But at the time, we had worked hard on getting the statutes regarding mediation passed. And so I had gotten trained probably a year before I was in that leadership position, and we formed a subgroup of the state bar and this joint committee for collaborative. And then, following that, we had started to have members who were non-lawyers, mental health, financial, et cetera. So we decided then to form the VACP. But my point is that Delegate Sullivan was really involved at that time, knew what collaborative had been involved in doing some of this ADR legislation. And he also is a lawyer at Bean, Kinney and Corman, and they have some attorneys. I don't know if anybody's on here today, but they have some attorneys who have been trained in collaborative and are doing that work. So it felt like a natural, and he agreed right up to go ahead and proceed and be a patron for us. So I think that was something that was very helpful in getting us going. And he introduced me to Lane Needler. And so with Lane's assistant as a representative of the ULC, we were really able to start getting things going. So there was I think most people know, there was a draft bill that then was filed in January of 2020. And once it was heard by the Civil Subcommittee, it was recommended that it be referred to the Supreme Court of Virginia so that they could basically look at it, get some input, etc. So it was passed over for the following year. The Supreme Court appointed this study committee. There actually weren't very many lawyers. I was the only lawyer that did collaborative that was on it. Dan Gray was also served on it, but there were several legislators and judges and some staff who were on that study committee. So in the first draft, we did include language about having collaborative lawyers being trained, and that caused a rather lengthy discussion in the study committee because there were people who asked what did that mean? And there was a lot of discussion about it. The UCLA doesn't use the word trained in defining a collaborative lawyer. The group very much thought that we should, as much as possible, be consistent with the UCLA and that there was a really reason to deviate. But at the same time, no one could agree that it should be put in the statute, that it was something that could be easily enforced, that we could define what the training would be, how to deal with people who took training in different states or countries. What if you have cases with lawyers from different states? I mean, there was a lot of discussion about how could we do this? And the bottom line is when we looked at it more closely, the conclusion was that there really aren't other areas where lawyers have to be required to take certain training by statute to be able to practice in a certain area. There are a few specialties for lawyers, but other than that, the reference was to the rules of professional responsibility for lawyers where they're obligated to be competent in any matter that they take on. So that's the history about the discussion about training. So the word training was removed, not because people think that anybody ought to be able to do it. It was really more a matter of how could we move forward with the act. That you trying to include something about training would delay it and possibly carry it over another year or two, and maybe even it die, without making progress. So, by the way, I should have said, and I'm not sure if anybody said, if you have questions or comments, to go ahead and put them in the chat. And our hope is to plow through our agenda and then go back and look at the chat for questions or even ideas that we might want to add to some follow-up discussion at another time. Okay. So the study committee looked at a few other things. There was a lot of discussion about whether there could be someone who is represented by legal services, and if that lawyer had to withdraw, whether that person could continue to be represented by another lawyer at legal services. And the language is about if someone qualifies for free legal representation within a firm. So I think the firm is being used loosely in the sense of it also applies to legal services. So there was a lot of discussion about that, and ways we could take the first draft bill and edit it so that it was more consistent with the act, and yet addressing a few of those key areas. So a report was issued by the study group. It went to the Supreme Court Justice. It then went back to the chair of the Civil Committee, and we had a revised bill that was filed by Patron Sullivan this year in January. And the great news is that it passed unanimously with everybody's support and everybody contracting their legislators. It passed unanimously in the House. And then there were a few votes against it in the Senate. The final vote, I think, was 2 people who opposed it. And then, what happened was that I was given notice when the act would be signed. We all were wondering, like, why was it taking so long? And so, I had the opportunity to go to Richmond and meet with the governor, and it was really great because he didn't I sort of expected I'd go in and just watch while he signed, but he actually had several of his staff and sat down and had, probably a 20 or 30-minute chat about what is collaborative, what are we doing, why is it beneficial, what's happening in Virginia and elsewhere. So it was really a great opportunity to be able to kind of take that a little deeper and, hopefully add more meaning to what was going on. So it's been signed. It goes into law on July 1st of this year. And we attached the actual statute language to the code, to the materials for today. So that is, I believe, the history that has, brought us to where we are now. So I'm going to turn it over to, I think it's Jen for her PowerPoint.
Yep, I'm up next. So I'm not a PowerPoint expert, so forgive me for any blunders. I want to say a couple of things before we start. One, part of the tagline on the email that was sent out to everybody said, what does the UCLA not say? And I had a whole list of stuff that it doesn't say. That's such a huge part of collaborative. And we decided it's just too much to bite off in an hour and a half. And we're going to combine that in a different presentation with what do you do with untrained professionals who are trying to do collaborative, because all of the stuff that the UCLA doesn't say really ties in with that. So stay tuned for a future presentation on that. 2, all the slides that I prepared reference the code section that I'm summarizing. You'll notice I've taken them out of order because in my opinion, the statute doesn't flow the way that a case flows. And so I've kind of reorganized the information to kind of go with the same order that a case goes in, just for reference's sake. And 3, I want to thank Michael McHugh, because this is mostly based off of an article that he and I co-wrote for the Family Law Quarterly, where we both had input on how do we cut this down into easily digestible language. So thank you, Michael. You'll recognize some.
Jen wrote the article. I got my name at the top. That's it.
So here we go. What does it say in plain English? Big takeaways. And anybody not Zoom competent with watching the screen, you can move your video screen around so you can see the slide better. You can change your view so you can see it better. All of this has been sent to you. It'll all be on the website. And this first slide is from Jan, frankly. She was like, these are the big things that we need everybody to take away with. And one is that the confidentiality of collaborative communications is now recognized by statute. Steve is going to be producing a new training on that issue later to come in the year or next year, because he dealt with that specifically in a trial that I handed to him from a collaborative case that fell out. Two, the court now has the authority to enforce the disqualification requirement. God forbid anybody, I don't think any attorney has ever been in the position of a client saying, I want you to represent me in court, and the attorney be in the position of saying, I can't. We don't have to worry about that anymore. And three, very importantly, I think the statute requires not only an initial assessment of whether there's been a history of family abuse, but also an ongoing assessment of that. And that's something, I think that's also something that could be a future training for everybody to become competent in. What does that mean? How do I do that? What do I look for? Next slide. So to start with, the collaborative participation agreement is addressed head on. It's the first, part of the statute after definitions. So it says the parties have to sign an agreement saying, here's our collaborative attorneys, this is what we're doing, and I intend to reach a resolution in this process. There's some other things in the statute. I'm just giving you the big takeaways. Another big part of the statute is that if the parties are in the midst of litigation, they can apply for a stay of the proceedings by signing a collaborative participation agreement and filing a notice with the court saying, we've signed a participation agreement, we want to stay. The court, hopefully, once the judges become more familiar with the statute and the process, will enter the stay. If for whatever reason the court refuses to enter the stay, the parties have to non-suit the case before they can then proceed with the collaborative process. I've had a couple of cases where we filed a suit for divorce and then entered collaborative without entering a stay. We just kind of agreed to sort of put things on hold. And so this, I think, changes the requirement of what we need to do formally in that situation. So the next statute requirement that I think is important is that for attorneys specifically, before a party signs a collaborative participation agreement, attorneys must explain these 4 things that are very important. And Jan's going to talk later about putting these in your retainer agreement to underscore, we've talked about these things, don't you dare come back later and say that we didn't. So the first one is that why we believe that collaborative is appropriate for this particular person's case. The second one is that, a comparison, cost-benefit analysis of collaborative versus other processes such as mediation, litigation, arbitration, having a custody evaluator, any other processes that the parties could possibly consider. We have to explain before they sign up, how do you terminate the process? Once you're in it, how do you get out of it? That's simple enough. And then we must obviously, I think, all of us do this anyway, but it really needs to be underscored that you have to explain the termination provision that, if the case falls out, I and none of the attorneys in my firm can represent you if you go to litigation. I don't think that I've ever forgotten to tell someone that, but it's possible. At the first meeting, I might have said, oh, did I tell you that? Okay. So going back to the family abuse provision, there is an exception if there is a history of family abuse that you can proceed in the collaborative process. Karen and I had a case where this was a situation. There had been 1 or 2 incidences of hitting of a child that one party regretted, the other party was a little disturbed by, but ultimately they decided to move forward in the process, and we had a coach and everything was fine. But the statute sets up now a very, objective standard for how to decide whether you move forward. 1, the abused party, the victim, has to say, I still want to do the process, notwithstanding this history of family abuse. And 2, the attorney has to believe reasonably that you can protect that party in the process from that abuse ever happening again, which I think makes sense. I think that in my training, particularly, I was taught if there's family abuse, you don't do collaborative. And I think that this recognizes that there's a gray area sometimes. And I appreciate that because, I think that sometimes you can move forward depending on the how serious the family abuse was. So this is another part of the statute that we kind of flagged as important to recognize. The statute says that, contrary to our participation agreement, which requires full disclosure, regardless of requesting it, we have to, under the statute, you have to request information in order for the other party to disclose it. I mean, I think that it's pretty common sense that you would just automatically request, please produce all relevant information. But this is, again, something else we need to underscore in the participation agreement, that it's not just upon request, that's not how we do things. We do it without requesting, regardless of whether the other person knows they should request it. If it's relevant, you need to produce it. And then again, there's a duty to update any relevant information that has materially changed throughout the process. The statute identifies exactly when the process begins and ends. It begins when your participation agreement is signed. We've previously circulated a retainer agreement that says, in between retaining an attorney and signing the participation agreement, your retainer agreement should have some language in there saying, the attorney is allowed to communicate with other professionals without a breach of confidentiality, just to protect you in that event. If you don't have that language, email me, I'll send it to you. And then it explicitly says when the process ends, when they've resolved all issues, when one person terminates, or when someone files something in the court. So communications by the parties and the professionals are confidential and not admissible in court. Again, this is one of the big takeaways that Jan identified. That's very important to know. Now it's not just a contract privilege, it's protected by statute. Obviously, there are exceptions to that privilege that are similar to what's in our standard participation agreement. Intent to commit a crime, intent to harm someone. If someone sues you for malpractice, you can submit their communications in the collaborative process to defend yourself. And obviously, information such as tax returns and bank account statements that's otherwise discoverable is obviously still admissible in court. It's essentially just our email communications, minutes, things like that are generated in the process that are privileged now. There's a termination provision about how parties can discharge their attorneys for any reason. Again, this is very similar to the language in our participation agreements that's already there. It mirrors our language that if a successor collaborative lawyer is not engaged within 30 days, then the process ends. It does say, though, that and this is something that I think it's fallen through the cracks in a couple of my cases, where if a new collaborative attorney comes on the case, they are supposed to be renamed and reaffirmed in the participation agreement. They need to sign it, and the parties have to reaffirm, we are starting this over with this attorney, which is, again, something that I have not practiced in the past, which I need to start doing. It's a very rare occasion, though. Okay, so here's another kind of, the yellow stars mean this is really important to pay attention to. So this is the disqualification provision, and it mirrors what we're all used to about if the process falls out, the lawyer and any lawyer associated with their firm cannot represent that party in litigation, except the statute says to incorporate a collaborative agreement into a court order. 2, where the star is, to ask a court to enter any order necessary to effectuate the terms of any agreement resulting from the collaborative process. Steve pointed out to me recently that he had had a conversation with Jonathan, and Jonathan said, wait a minute, does that mean that, Jonathan Kales, if you're on here, does that mean that I have to file a rule to show cause on behalf of my collaborative client if the other party is not complying with the agreement? I think that the statute allows for that, which I think that all the attorneys would agree we wouldn't want to really sign up for. So Jan's going to talk more about that, about having a provision in your retainer agreement and the participation agreements that says, I can represent you to effectuate uncontested orders like quadros. I'm not going to effectuate orders that are contested, such as rules to show cause or motions to enforce. I think that all of us want to avoid that sort of situation where you're suddenly litigating in a collaborative case. So I don't know if that was an oversight in the drafting language, but I think it's something to be aware of. And then obviously, again, to seek or defend for an emergency protective order. That's something that's similar to what we've contemplated before. There is in the statute, it sort of elaborates on the conditions under which you may represent a collaborative client in an emergency protective order situation. It's specifically, it's like the choose your own adventure diagram. It's only if another lawyer is not available to represent them, and only until the lawyer is available to take over the emergency order, or reasonable measures have been taken to protect the client. You get them out of state, they're staying with their mom at an undisclosed location, the abusing party's in jail, whatever it is that maybe that takes the emergency away, then you can cease your representation. And then the last slide is just a summary. I think most of us in Northern Virginia, this isn't necessarily going to apply to us, but if your firm has a policy where certain individuals qualify for free legal representation, it sets forth a procedure whereby your client in a collaborative case may actually be represented by another lawyer in your firm if they qualify for the criteria set forth by your firm. And it says in the participation agreement that you're making an exception, that the disqualification provision won't apply to someone else in your firm if the case falls out. And then if the case does fall out, you as the collaborative attorney are isolated from any further participation in the case for the free legal representation. I think this is probably going to be a rarity of any sort of application, but it's worth knowing in case it comes up. You just never know what you don't know. So I'm going to stop there. I think I talked at super speed and left enough room for Jan.
Can you make me a co-host so I can share my screen?
I did already. Let me verify.
You are, Jan. I think you are.
I am? Okay. Let me find my documents here. Okay, can everybody see the act?
I see your menu on your computer, but not what you've opened up.
Oh, okay, because I can see it. Let me stop sharing.
And I want to
Let's
see what
see.
recipes you got in there.
Okay, let me try again. How's that?
Yes.
Okay. Okay, now let me just switch to let's see if I switch to can you see the participation agreement?
Yes.
Okay, we're good to go. Well, after those two good presentations, I hope I don't bore you to death, because I'm going to be giving you a lot of statute numbers and paragraph numbers of the participation agreement. But basically what I'm going to do is go through with you the changes that have been made to the collaborative participation agreement and engagement agreement to reflect the Virginia UCLA. Now, by the way, there are very few changes to the engagement agreement, really only one, which is to recognize the authorization for the collaborative attorney to handle a protective order for the collaborative client under certain situations. The big picture is that you will find that the collaborative participation agreement, and to an even greater extent, the engagement agreement, have not changed a great deal from the DC Metro Protocols agreements that we distributed back in 2010. And the reason is that we had the UCLA at the time, and DC passed the UCLA just about 2010. It may have been in 2010, but we knew the UCLA was passed. We had all the provisions. And so we, the DC Metro Protocols Committee, drafted the participation agreement and the engagement agreement to conform to the Uniform Collaborative Law Act. And then when DC passed it, and then Maryland was, I think roughly 2014 passed it, we, the DC Metro Protocols Committee, went back and made additional changes. And then, you know, sort of without involving the whole committee, but basically I, on behalf of the DC Metro Protocols Committee, when this passed in Virginia and we were so elated, I went back and made the changes to conform the Virginia agreement. Just to start with one, well, first of all, you have on the website and also emailed to you the Word version of the revised participation agreement and engagement agreement. And so you can take it and you can adapt it, you know, as always, adapt it to your liking. You know, that's what people have always done. But you've got the basic DC Metro Protocols participation agreement and engagement agreement, taking into account the UCLA changes, and it's in Word and it's on the website and it was also emailed to you. So use it as you like it. Then if you want to see the exact changes and you forget what I have said, or you think it's too boring and you zone out, I also provided to Morna, who put on the website, the PDF of the red line version, which is what we're going to be looking at tonight. And the red line version shows the actual changes that have been made from the old protocols agreement. So if you took the old protocols agreement and you made your own adaptations that you like, just so you know, that's what we worked from. We worked from the old protocols agreement. Now, one of the big points that we haven't mentioned tonight, but it's interesting and something to keep in mind, is that the Virginia UCLA only applies to disputes among family or household members or arising out of the domestic relations law. So that's like DC. DC, that UCLA is limited to family law. I think the intent was always to go back and see if we could extend it. But Mary Pence, who really, you know, spearheaded that effort, is retired now. So I don't know that, you know, I don't know who would be taking that on. But DC is limited to family law. Maryland is not. Maryland, you can, Maryland, the UCLA applies to anybody doing a collaborative case of any sort in Maryland. And so it's not that in Virginia and DC that you can't do a collaborative case. You can do a collaborative case, of course, whether it's family law or not. It's just that the obligations will be contractual. They won't be statutory. And that's really the big takeaway from the UCLA. And what I'm so excited about is that now in Virginia, whereas we used to rely on the contractual obligation and hope to God that the judge would enforce it, and there was mixed case law on it, as you know, now we have the protection of the statute. And that's why, you know, I was so excited that, to me, the two big accomplishments are that we now have a statutory collaborative communication privilege, and we have a statutory enforcement of the disqualification provision. Because it sounds like Steve has had some experience with asking a court to enforce those contractual provisions. But at the time, the DC Metro Protocols and also the Ethics Committee that started in Maryland, but really covered all three jurisdictions. At the time we wrote our different papers, there was one Canadian case where a court had enforced a collaborative participation agreement. We didn't know of any appellate cases in the US, and we had, you know, word of mouth reports from mediators that if they were in states where there was no mediation statute, the court did not always enforce the mediation contract for confidentiality. So the huge takeaway now is that we have a statutory communications, collaborative communications privilege. So now let me go to the statute. And you will see here is the definition of the collaborative law communication. And that is a statement, whether oral or in a record, or verbal or nonverbal, that is made to basically participate in a collaborative law process and occurs during the process from the time between the signing of the collaborative law participation agreement and before the conclusion of the case. So do remember that when you're just getting started and you're meeting with the other professionals and you're talking to opposing counsel, you don't have this privilege yet, nor do you actually have the contract that would provide for it being a collaborative law communication privileged statement. And then if you go to, let's see, (2182), this creates the privilege. A collaborative law communication is not admissible in evidence and is not subject to discovery. And then there are two exceptions, or there are a few exceptions to that. So this is when a successor attorney, let's say, is in court and someone wants to introduce a collaborative law communication, who may assert this collaborative law communication privilege? So a party may assert the privilege to prevent any collaborative law communication from coming into evidence. Next, a non-party participant may prevent that person's collaborative law communication from coming into evidence. Now, who is a non-party participant? I think all of you know, but a non-party participant, as defined in the statute, is one of the professionals, the professionals other than an attorney. So it's not the parties and it's not the attorneys, but it's anyone else participating in a collaborative process. So basically, the coaches and the financial neutral can assert the privilege as to their own statements if someone else tries to introduce that into litigation or to ask for it in discovery, and they can prevent that. Now, attorneys cannot. If both parties, it would be unusual, but if both parties wanted the attorney's communication to come into evidence and the attorney really didn't want it to come into evidence, both parties could they could agree that it would come into evidence, and if the attorney objected, the attorney could not stop it. And when I first heard about that, I thought, well, that must be a mistake, or what happened there? And I asked Mary Pence, who once again, she was sort of ever present back there working on the UCLA, but she was familiar with what had happened in the Uniform Commission, and the attorneys were accepted on purpose because of the long history of attorney-client privilege. And that is the client's privilege, as you all know. And so the decision was made that the attorneys could not block a collaborative law communication from coming into evidence. The parties can, and the non-party participant can, with respect to their own statements. Now, there are many exceptions, and let me just get to that section. If you look at 2184, it lists the exceptions to the collaborative communications privilege. And none of these will surprise you. These are, if you go through the typical exceptions to confidentiality, a threat or statement of a plan. Well, first of all, available to the public. I skipped that one, sorry. If it's already available to the public, if it's a threat or statement of a plan to inflict bodily injury or commit a crime of violence, if it's a statement intentionally used to plan a crime or commit a crime, if it's in an agreement, a signed agreement that results from the collaborative process, none of these are privileged. If it's sought or offered to approve or disprove malpractice or professional misconduct case, oops. If it's sought or offered to prove abuse or neglect of a child or adult, there's no privilege. Also, there is a provision that if a case involves rescission or reformation of a collaborative contract or a felony or misdemeanor, that there can be an ex parte hearing if the party seeking discovery has shown that the evidence is not otherwise available and the need for the evidence substantially outweighs the interest in protecting the confidentiality. And of course, let's see, there's one other here. Oh, and that there is also, the other is that if someone introduces a collaborative law communication against a party, then that party can introduce in response a collaborative communication. So none of these, I'm sure come as a surprise to you because they're pretty typical of exceptions to confidentiality. So now let's go take a look at the confidentiality agreement. Excuse me, the participation agreement and its provisions. Oops. Here we go. So if you will look at this, you see there's no red line here, and that's because when the DC Metro Protocols Committee drafted these agreements, we made DC, Maryland, and Virginia similar as much as we could. And we also made all of them as consistent with the Uniform Collaborative Law Act as we could. And so you will see that the definition of the collaborative communication is consistent with the Virginia UCLA. And you will see that the statement that the collaborative communication cannot be introduced in evidence or compelled to be produced in discovery is the same as the Virginia UCLA. And that the people who can assert it, that is the parties and the basically a non-attorney team member with respect to their own communications, all of that is already consistent with the agreement that if you've been using the protocols agreement or something close to it, it's already consistent with the UCLA. But the problem, of course, was that it was a contractual commitment. And, we don't really know. And it sounds like Steve had some experience, and maybe some others of you did, with what a court would do and whether a court would actually enforce this. We certainly hope so, but we didn't have any existing case law to base that on. So it's a huge relief to get the statutory privilege. And then let's see, if we go down to D, here you see all of the exceptions that I just read straight out of the statute. They're all here. And there's one at the very end. There's one that there was an extra one in here. And it's down, you can see it crossed out. And that did not come from the UCLA. So I took it out because I wanted this to conform to the Virginia UCLA. I think it came from DC or Maryland and had, I think, a statute on this. And I think that's the reason we put it in the original model participation agreement. Okay, so now the next, I'm going to go back to the statute a second. The other thing that I'm so excited about, I waited a long time for this. I don't know if you all felt the same way, but now I sleep a lot better. The oops. Okay. The disqualification provision. And here it is, 20175 in the statute. And so a collaborative lawyer is disqualified from appearing before a tribunal. And as you know, it's a little bit broader definition, but basically that means a court, to represent a party in a proceeding related to the collaborative matter. And related to the collaborative matter is defined at the very first of the statute where it has the definitions. But it's basically involving the same issues, parties, facts, you know, but that you can look up and be precise about the definition. It's at the first of the statute. And then the disqualification extends to a lawyer in the law firm with the collaborative lawyer. And then, as Jen said, the disqualification in here, there's an exception for a collaborative lawyer to ask a court to affirm, ratify, and incorporate any agreement resulting from the collaborative law process into a court order, which basically is going to be a consent motion to enter the collaborative settlement agreement that the parties reach, or any interim agreements to be relied upon that come out of the collaborative process, or perhaps consent motions having to do with quadros. And then again, as Jen said, and she and I talked about this, and we're in agreement, and it sounds like Jonathan and some of the others of you have stumbled on this, that the Virginia UCLA does authorize us to ask a court to enter basically any order enforcing the agreement. And you'll see how we dealt with that in the participation agreement in a minute. And then the big one, and this is a huge change for us, there is an exception that a collaborative lawyer may seek or defend an emergency order to protect the health, safety, welfare, or interest of a party or a party's family or household member if a successor lawyer is not immediately available to represent such person. And that applies, as Jen said, until there is a successor lawyer or the reasonable measures are taken to protect the health, safety, welfare, or interest of the person who is at risk. Now, so now let's see what we did on the participation agreement here. Okay, so you can see this is a big change. We had in here originally in the participation agreement in paragraph 2D that, you know, the parties agree that neither their attorneys nor their firms can ever represent either party in a contested court proceeding against the other than for a mutually agreed submission of documents to obtain an uncontested divorce or other mutually agreed consent order. So now we pick up the statutory language from the Virginia UCLA to add, to ask a tribunal. We probably should change that to court now that I think about it, to be a little more grammatically consistent with the rest of the agreement. But anyway, to ask a court or tribunal to affirm, ratify, and incorporate any agreement resulting from the collaborative process into a court order. Okay, so that's not very controversial, and it's about very similar to what we already had in there. To enter any, and here's where Jen and Jonathan's point, and I think there was somebody else who, I've forgotten, Steve, was it you, but somebody else who was making the point, do we really want to be appearing before a court to try to get a contested order entered? And I think the answer that most of us would give is no, we really don't want to do that. So so we say we can appear in court to enter an uncontested order necessary to enforce the agreement. And maybe, you know, if you're going in to enforce the agreement, maybe it's really going to be contested. So maybe you're not going to be doing that, but we're only agreeing to enter uncontested orders in this agreement.
Jan?
Yes.
I was looking at the comments and the actual UCLA, not, you know, how it compares to our statute. And, you know, I believe that what was intended here, so the actual act does not have that language in it. And I believe that our Virginia statute was intended to mean orders such as quadros, et cetera, you know, consent orders, basically. It was definitely not intended to be rule to show cause or any of the like. I was looking at the actual act and the comments under the act were the exceptions to disqualification were for seeking emergency orders for limited time and to allow collaborative lawyers to present agreements to the tribunal. And so the reason this additional language for the Virginia Act was in there is because it addresses agreements, but it doesn't address like consent or retirement orders or the like. And so I believe that's what was intended. And I think that using in our participation agreement, making it clear that it's consent orders. So I think, you know, I suppose you could have a situation where you have a collaborative case and the case reaches an agreement, and for some reason the client tells their lawyer, one of the clients tells their lawyer, I'm done, I don't need to pay you anymore, we're no longer in the collaborative process. And the other attorney seeks to have a retirement order entered, but it's not signed off on. You know, that could be an area there where there could be.
Okay, well, that makes sense. That would be my guess as to what was intended.
Right.
Yeah, that is really like a quadro situation or something like that, where there really is no dispute.
So
exactly.
let me add the case that I had with Steve Goldman, and he kind of touched on, was a situation where my client was very slow to reply on things. Sometimes I wonder whether it was purposefully, but there was a quadro that Steve's client wanted entered, or a retirement order, and my client just wasn't responding. And the issue was, you know, could Steve notice me without, and my client's not communicating with me, notice me to a motions day to get the quadro entered with this new statute. Now, we signed a participation agreement prior to the new statute, so the answer in our case was no. But if we, with the new statute and all this revised language, I wonder if I could have been standing there, noticed to a hearing with with a client who's not responding. And that's kind of a place I don't want to be, but
Well, especially since in that situation that we were in, Jonathan did enter an appearance because he was part of getting the final order of divorce. So now he
Right.
is attorney of record. And I don't need to go and serve, let's say I decide to do it in form of a motion instead of a rule to show cause. He's already attorney of record. I'm just noticing him for it.
Yeah, so here you want, if you've put in this word uncontested order, you've protected yourself in the sense that your client is signing that you don't, this is not an exception for you to be able to appear. You actually cannot appear under the disqualification provision as it's drafted here in this red line version.
Well, it
Would you-
doesn't, in theory, it doesn't become uncontested until there's notice and the other person contests it.
Yeah, I think the issue that I see is sort of the same one we were talking about before, is now you're protected by a contract, but still not an order. And
Yep.
so if I end up, serving the motion on Jonathan in that situation, he is attorney of record. There's nothing that's being wrong otherwise, unless, I had I wasn't allowed to do it. But I think that Jonathan would still be stuck fighting just the contractual language that, hey, I should be out of this, and this person should have to hire somebody else.
Well, yeah, and I guess the question is, if Jonathan cannot appear, he can't argue to the judge his contractual reason that he can't appear. In other words, Steve, you wouldn't be pointing it out. And so somebody would need to point out to the judge that, hey, Jonathan's not obligated to appear. And if Jonathan doesn't appear, he can't do that. That's really a catch-22.
I think this could be I think that we have several topics relating to, like, when does the collaborative matter end, and how do we handle it in these divorce situations if someone doesn't, sign off on getting the agreement incorporated or getting it quadro. So I think we should, people can put their comments in the chat and have a follow-up, discussion or program on this issue.
So, okay, so I'm going to be very quick about this next thing, but you will notice in brackets, if your law firm thinks that you might want to, that another lawyer in the firm might want to continue to represent your collaborative client, if you're no longer able to do it, then for free, which I realize for most of us is a pretty unlikely situation, but this bracketed language would allow you to have a fellow attorney in the firm continue after the collaborative case ends, working for free for the client. You have to have it in the participation agreement to make that happen. And of course, the original collaborative lawyer has to be isolated from the successor case. Okay, so now I'm going to change to a different topic, which is, and Jen discussed this very well, and it is, let's go back to the statute. This is the lawyer's duty before the case begins to assess with your party various things, but particularly whether the collaborative law process is appropriate for the party and the risk and benefits of alternative processes, and advise the prospective party that, let's see, let me scroll down here. If the party initiates a proceeding, a court proceeding in a pending collaborative matter, the collaborative case terminates, that participation in a collaborative law process is voluntary, and either party, with or without cause, can terminate it. And with limited exceptions, the collaborative lawyer and any lawyer in his or her firm cannot represent the client in a related matter after the collaborative case has terminated. And we've discussed those exceptions already. So this is what we have to tell the client. We've known this for a long time. This was in the ABA ethics opinion that we all relied upon as the foundation when we used to be challenged as to whether collaborative law was ethical. And we had to do all these things, and we know we have to do these things. And there is language in the participation agreement already about this. The Virginia UCLA is more specific, particularly about the part about if advise the party that if they initiate a court case during a collaborative law process, the collaborative process terminates. So the Virginia statute is a little more specific. Now, the big change comes in 2180, the history of family abuse, as Jen stated. The lawyer has to make reasonable inquiry into whether there exists a history of family abuse. And then the lawyer has to continually reassess that. And if the lawyer reasonably believes that there's a history of family abuse, then the lawyer cannot begin the case unless the party requests to begin the process, and same with continuing the process. And the collaborative lawyer has to reasonably believe that the safety of the party or prospective party can be protected during the process. When there was a big history in the UCLA, before the commissioners, that and there has been, and I think maybe not in Virginia this time, but certainly in DC and also in Maryland, the domestic violence advocates have been very concerned about collaborative process being used. And this is the background of these provisions, that this is what was worked out in order to protect domestic violence abuse victims. And when DC passed this first statute, the UCLA, we realized in DC ACP that many of us, and I certainly was among and still am among this group, not nearly as knowledgeable about domestic abuse victims as we should be. And we commenced, and here's another program idea for next year, we commenced a lot of education in our practice group. And we had domestic violence advocates come in. I had little lipstick containers that had the House of Ruth and some of the other safe place phone numbers, because if you think about it, there's no place that a domestic abuse victim can keep that information safely. And Mary Penn, I keep mentioning Mary Penn, she should get royalties or something, but she came up, or she got it, I don't think she drafted it, but she got it from somewhere, a very long questionnaire to determine if a client is a domestic abuse victim, because there are a lot of things. And also we learned a way of talking, don't ask if there's a domestic abuse, ask what happens if somebody gets angry, and you then just have to pick up nuances to try to figure out, because very few people, maybe, well, I don't know how many people, but many domestic abuse victims do not admit what's actually going on. So now let me go to the participation agreement on this, and let's see. So this, as you know, the attorneys do not sign the participation agreement. They sign, at least in the model, the protocols model participation agreement, they sign a statement that they agree to follow the instructions that the client has given them in the participation agreement. So this number 16 is the client is signing this, and this is an acknowledgement of all the things that the attorney has done to meet the statutory requirements. And so we filled in a little more detail about, the fact that filing in court will terminate the process, but we pretty much had covered the attorney's obligation that was derived from the ABA ethics opinion to assess with the client whether collaborative was appropriate. And so the new part really is that the client will be signing that each attorney has made a reasonable inquiry into whether there exists a history of family abuse, etc., and has complied with the statute. So this is intended for two things. One, if the client reads it, hopefully they will, and hopefully you'll go over it with them, they will know that the attorney is supposed to do this, and hopefully will let the attorney know if the client thinks the attorney has missed any of this. And it's also to remind the attorney, as the attorney goes through this, as Jen says, so once in a while you forget to say to someone in that first meeting, oh yeah, there's a disqualification provision, and you hope you remember to tell them pretty soon. But if you forget, when you sign the participation agreement, here are all the reminders to the attorneys so that they really have met the statutory requirements.
Jan,
Yes,
I don't know how much more you have left, but I'm doing a time check. So it's almost 7:15. How much more do you have?
about 5 minutes.
Okay, that'll allow 5 minutes on the social media. I could probably.
Okay, well, yeah, all right, well, let me skip the screen share and just talk to people about the rest of it, because then I can do it in much less. And that is that section 2177 requires, the UCLA requires the parties to disclose information on the request of a party. And as Jen said, our participation agreement does not require that a request be made. It is an obligation to disclose whether any request is made or not. And that is paragraph 3A in the participation agreement. And by the way, the definition of information to be disclosed in the protocols agreement is important information. And we picked that because it didn't have any of the legal baggage of material or relevant. And important is defined as if it's important to the other party and making an informed decision about the issues. And then the last point, which we have talked about, is in section 2172. And I will show this because there's a provision in here now. Oops. Oops. The stay of the court proceeding. And so the parties, when they sign this, they are saying that if they are currently parties to pending litigation, they agree to file a consent motion consistent with the statute and to comply with that section. And I have had 2 cases in this with a stay in Maryland, and it's a wonderful provision. So I think that is it, and I'm done.
Okay, all right. So if I can, let's see if I can share my screen. Are you able to see the marketing tips and quick list? Yes. Okay. So I'm not sure if this was included in the materials. I sent it in, but I didn't see notice that it actually made it through. So this is my attempt to, share some of my thoughts about, ideas about how everybody can move forward in doing something on their own quickly we have groups coordinating efforts, but I think as a group as a whole, the members can really take some individual actions that will help, get the message out. It's a great opportunity to use it for marketing. When we say marketing, it's education. So just a kind of a quick list. I will also share it so anybody can refer to it after the meeting from the website. Basically follow IACP, VACP, and CPNV on social media. I saw that there was a message that came out to me about following VACP just came this week. So I don't know if everybody's getting that message, but it's clearly an initiative that the VACP is trying to get going. Share something about the UCLA on your social media, LinkedIn, Facebook, other. Share each other's posts about collaborative. There are, the IACP posts several times a week. I see it mostly on LinkedIn, but just sharing that information gets more word out about collaborative in general. And, it's a great form of quick, free marketing. Tell your friends and family on Facebook. It's obviously a professional thing, but if there's something that you feel passionate about it and you want to share it with friends and family, again, it's a great way to just educate people and remind them what you do and, why this is important. Add something in your firm or business newsletter if people have something like that, put in a quick blurb about it. Write a blog for your website. Be sure that your website has something about your offering collaborative services. I know I've seen some of our members, I'll go to the website and it looks very traditional, lawyerly with the gavel and the scales of justice or whatever. And I think sending a message that has to do with ADR as a strong component of what you do can really go a long way. Add testimonials to the website specifically from collaborative clients. Maybe they can mention the collaborative process in the testimonial. Having a folder of materials ready that you can give to clients. If you're not meeting them in person, have some kind of folder in your, your documents file that you can quickly refer to and send to clients who are interested in collaborative. I'm doing this year-long monthly trainings with Ronowski and Woody Moston. And actually the last program we had, David Hoffman was the presenter, and it was about areas of maybe disagreement or controversial that go with collaborative participation agreements. And, their comments were get that sample participation agreement out to a client before you even get retained so that they can read it. You can ask them about it. Their opinion also was have 2 or 3 meetings before you commit to be in this process, possibly have a meeting with the other party and their lawyer and your client before you even commit to go collaborative, so you can evaluate how the other person engages, etc. So anyway, that was a suggestion, I picked up from that class among many others. So reach out to your key contacts and referral services to let them know about this update in the law and what's happening with the collaborative. So hopefully they'll consider that when they're making referrals, whether it's another lawyer or just, someone of another profession that makes referrals to you. Work on a press release. You could do it individually. If you have contacts, our task force would, love to have them so that we can try to reach out to the press about this. My feeling is it's happened. It's got signed, towards the end of March, but it doesn't become into law until July 1st. So we have a lot of time to work from this event. Encourage people who you think might be interested in getting trained. Now we have the statute that, makes this participation agreement and the disqualification clause law. Informed consent, it's a great opportunity to try to get more people trained. or refer to the process. Writing articles, I think our task force is doing some of this, writing articles. I know there's reference to Michael and Jen doing an article. Looking at your local bar association, specialty bars. And for those who aren't lawyers, similar groups within your communities in the mental health or the financial field. Really trying to get the word out. Arrange to speak to groups who are listening, tell anybody who you feel like, just a little bit about it. I think that if everybody could just pick, 2 or 3 things here and do it, it's really going to help to create that educational awareness, which is what we're trying to do. I'm sure there's a lot of other things people could do. You should put them in the chat. And this was just my quick list of, ideas. So I think we're now into questions and answers. I was going to take a look at the chat, so I'll stop sharing.
I think we've answered all the questions in the chat. Does anyone else have any questions that they didn't put in the chat? I was going to ask Patrice, unrelated, and I'm sorry if I missed this earlier. Are there any poll results from our summer social about what's going on with that for June?
We are going to do, instead of this summer, we're going to do it. It was a consensus to do it in September. So we're going to wait so we can do it outside somewhere. Everybody feel more comfortable.
Nice and cool.
Yeah. Yeah. And I want to thank you guys for this. There's definitely, I was just sending a text to Nat. This is a follow-up. We definitely have to have a follow-up because there's a lot to talk about on this. And this, thank you so much. And I'm so glad it's recorded. Is there any other questions? We have like 5 minutes if anybody has any questions. No. Okay.
Cheryl?
Cheryl.
Hi, thanks for letting me join
Welcome.
in. I'm all the way from Roanoke.
Didn't you realize that?
I did.
I'm so used to you being on Zoom, I didn't realize that you're a guest.
Thank you guys. I like being just a part of the group. I did have a question back on the PowerPoint, Jen, and it was on section 2171. And it mentioned that, the parties can discharge a class of lawyers. And it says, and the lawyers may withdraw from their representation at any time. But I've kind of had always been of the mind that lawyers couldn't terminate the process. Withdraw might be the operative word there that I'm not, thinking about. But I think we withdraw, when clients won't let us, share information that we've talked with them that needs to be shared, and we can withdraw for that. I suppose if we needed to withdraw for a personal reason or something like that. But I guess the way I was reading it, was a little concerned that it was just saying, oh, we could just hop on out. When in fact, I felt like we couldn't really jump out of the process that quick.
Well, I had a case with Karen where that was a very difficult decision that she had to make. And the team essentially she did not, she felt an obligation to her client, and we all said, Karen, you have to withdraw. Your client is emotionally abusing you. It was that terrible. And for what you're saying, she felt, I have to stay representing her in this process, but she had to withdraw for personal reasons, and Karen, I apologize. I don't want to speak for you, but it was a very unusual situation, but I think the statute supports that decision. Absolutely.
If I could just add,
language. I was looking for the key language, Cheryl. Which section is it? I see 20-171. Where that is.
There's the provision is termination. Only the client can terminate. I mean, that's clear.
Right.
Were you questioning that, Cheryl?
Your fees, for instance, your client refuses to pay you, you have the right to withdraw.
Yeah, I will say, we dealt with this in the ethics in the ethics report. We dealt with the guidelines for withdrawal by the attorney, and each state, including Virginia, has rules of professional conduct, and you have to minimize the prejudice to the client. when you withdraw. So that you do have to, you know, you can't just withdraw without sort of looking at the rules and thinking, okay, you know, if I withdraw in this way, to what extent is the client going to be prejudiced? If I if I withdraw in a different way, you know, you just have to think about it all, because there are ways you can do it with minimizing the prejudice to the client, but you have to be careful about it.
Yeah, I mean, I think the case of I'm recalling is that I terminated representation, but I didn't terminate the process.
Right.
Right.
And was up to
I think that's the
party.
distinction. And Karen,
Yeah,
I
so-
see in 2171(3), it says, except as other provided, a party discharges a lawyer or a collaborative lawyer withdraws from further representation. So, yeah, I appreciate that discussion, because I was trying to get my head around that distinction.
Right. Well, so what happens, what that means is that when the attorney withdraws, the process has to terminate until the client gets a new collaborative attorney.
Well,
But if the client-
it's a stay, it's a holding period. It's still in the process pending the client getting a new attorney. If they don't, then the process is terminated.
Right, that's correct.
And these are good, I think, great questions. There's a lot of work still to be done, sorting through process and these difficult cases and situations that we find ourselves in. And I'm hoping at some point we can move forward with having more of those discussions. You know, I know this was a nuts and bolts program, but I know we've all had some pretty sticky cases. And they don't always go as nicely as you might think when you get started, you know? So, you know, hopefully we can continue to learn from one another in those. Anybody have other questions, comments?
I would just like to say, I hope we can have some training in domestic and violence and handling those cases.
Yeah, that's the other thing that we're definitely going to talk about, hopefully in the fall.
We'll put something on the calendar sometime either in the fall or in the spring next year, but we'll work on getting something on the calendar.
Mhm. Great.
And I know that there, at least one of our members has volunteered. She was on here earlier to have some experience with that and has volunteered to do some training on it.
Oh, good.
Yeah.
Yeah, well, please let me know if you're still on here. Just reach out to me.
Yeah,
I
definitely.
think it was Leishan Dunst. I'm not sure if I got that,
Durst.
but
Durst.
yeah. Yeah. And I saw a couple people, I didn't recognize their names, Becky Kinzel and Tashina Gorgoni. Are they members?
Tashina is at Maddox and Jirac.
Okay.
Yeah, Rebecca is a guest.
Yes.
Okay. Good. Well, I don't know who's still on, but Rebecca, if you're still on, welcome as a guest.
Karen and Jan and Jen, thank you so much. We're definitely going to plan a follow-up. This was very, very informative. And there will be a June, in place of our social, we are going to have some sort of training. We haven't decided yet, but we're working on it. Okay, everybody have a great week and thank you again.
Thank you, guys. It was great.
Thanks for
Thank
joining,
you.
Carol.
Thank you.
Thank you all.
Yeah,
Bye, everybody.
thank you.
Bye.